Without further ado, I will go ahead and introduce Title IX Solutions. Some of you are new here and you're not familiar with the work we do, which is great. We're happy to have you. So we started and specialize in exclusively professional Title IX investigations on college campuses. We have a group of former FBI agents who are trained in Title IX and also licensed state private investigators who we essentially deploy to conduct investigations on campus, particularly for those more complex cases that just require some expertise. We also offer training programs for campus-based investigators and Title IX coordinators, and now those courses will be available for disciplinary, hearing, or decision makers, or whatever your school calls them, members. So we offer both small training for just your campus and also regional campuses where a host institution invites us, and then together we invite coordinators, investigators, and decision makers from surrounding colleges. With the new regulations, which have been recently released, that's hard to say, we're also offering sexual misconduct policy consulting services. So we essentially will help you bring your school's policy into compliance. We understand it's a lot to go over, especially in the midst of what's going on right now. So we're here to help with that as well. Finally, we provide consulting for international schools. We have a few international audience members here today, so thank you for joining. And you can learn all about our 4 services on our website. So I encourage you to check those out. Pat Mathis is our presenter today. He's our co-founder, managing member, and attorney. Lifelong attorney, so much knowledge. He is a shareholder at Mathis, Murphy & Richter. It's a law firm here in Southern Illinois. And he's been a college trustee for over 12 years. So he understands both the legal implications of Title IX, but also kind of the liability and behind the scenes administrative aspects to higher education. So he typically designs our training programs, leads our training programs, and works with Title IX coordinators and administrators a lot. So he has really prepared for this webinar today. He's read the whole 2,000 something pages. So you truly have a Title IX expert in front of you, which I admire because so it's a lot to get through. And I hope you find it helpful today. So I'm gonna go ahead and cut my camera off. I'm gonna show you the PowerPoint. And as I mentioned, just please send Pat and I questions after, and we'll get to you or create a new webinar, and we hope to see you next time. Pat, I'm gonna let you take it away as I figure out how to share my screen.
Thank you, Adrian, and welcome. Thank you all for being here. As Adrian mentioned, I've been a trustee at a liberal arts college for a dozen years, and I understand that you all in higher education have much on your plates today, including the final Title IX regulations, and that your time is valuable and precious, and so we appreciate you taking this time to spend with us this afternoon. As Adrian mentioned, the pronouncements that came out of the Department of Education in May, if you've spent a little time looking at the primary link, are a little over 2,000 pages, and I will confess that I skimmed through the parts that I didn't think were as relevant as others. So, but if you're looking at that set of materials, the regulations themselves are actually the last 30 or so pages. So if you scroll through, go to about page 2002, and you will be where the regulations themselves start. A little bit of dry reading in the best of situations, as are most federal regulations, but that's the way it works. So what we have done is, after looking through the regulations, there's a lot of interplay between the various provisions as far as definitions go, and the directives for procedures that schools are to put in place. So what we have done is we've tried to organize the materials for today's program in more of a logical, chronological order. As a school would face an allegation of sexual misconduct on campus, how the school would address it initially, and then through the grievance process itself. So within the materials, what we have done is we have included a reference to in each paragraph as to the section of the regulations that is specifically addressing that part of the outline, so that if you like to refer to the regulation itself, you can go there directly. We've also referenced provisions in the preamble where we thought that the comments from the Department of Education were particularly relevant to a topic that we were discussing within the outline materials. You will also find that some of the materials are verbatim from the regulations themselves, and others are summary provisions to try to eliminate some of the duplication within the language of the regulations. So we hope that it is helpful for you, as Adrian said, both today during the program and going forward as you are addressing, updating your policies, or as you may be addressing your initial investigation or a hearing or other part of the required processes under Title IX and the new regulations. So that's a little background on what we're going to do here today. Just a bit of an introduction. As most of you know, the regulations cover post-secondary schools and also elementary and secondary schools. And within the definition of post-secondary institutions are graduate and undergraduate schools, vocational schools, and professional schools. Within the definition of elementary and secondary schools are preschools, as well as private elementary and secondary schools. There are some places in the regulations where there's a differentiation between post-secondary and elementary and secondary schools. We'll point those out to you during the course of the program, and they're also noted in the materials. There are only a couple of spots, but they are relevant. The effective date for implementing the new requirements is August 14th, 2.5 months away, not much time and much to do. So again, we'll all be busy. Schools must comply with these new regulations. That's the mandate under the regs themselves. But I would note that the regs also make it clear that schools' codes of conduct may address related issues as they might relate to sexual misconduct, provided that those additional requirements under a code of conduct have to initially comply with the requirements of Title IX and the regulations. So, for instance, the regulations only apply to sexual discrimination or sexual harassment of an individual in the United States. So students studying abroad are not covered under the regulations, but a school is free within its code of conduct to incorporate provisions that might address incidents of sexual assault or sexual misconduct that affect a student who is studying abroad, either as a complainant where the school may be providing supportive measures, or a respondent where a student is alleged to have committed some form of sexual assault, and the school may undertake a disciplinary process outside of the Title IX requirements. Similarly, the definition of an educational or program activity that a school is responsible for is relatively limited under Title IX, as we'll talk about in a few minutes. But a school might expand that to, for instance, incorporate sexual assault involving two students of a school that may occur off campus and outside the scope of educational program or activity, but is nonetheless perhaps in one of the students' off-campus apartments where the school feels that it is subject to the code of conduct for that particular institution. So, guiding principle throughout all of the regulations is that students are to be treated equitably and equally, and you will see those words come up repeatedly throughout the regulations. It is a byword that we need to keep in mind throughout the process. And finally, We'll use the term recipient and school kind of interchangeably throughout the next 45 minutes or so. And the Department of Education similarly uses those terms interchangeably to address any institution that receives federal financial assistance under Title IX. I'd like to begin by talking about the definition of sexual harassment, which is the seminal topic under the new regulations. And there are three types of defined sexual harassment under the new regulations, all of which are based on conduct which is on the basis of sex. So keep that qualifier in mind. We'll come back to that in a little bit. The first is what's termed quid pro quo sexual harassment, where an employee conditions an aid, benefit, or service of the recipient on an individual's participation in unwelcome sexual conduct. And I think that's pretty straightforward. Most of us understand that. The second type of sexual harassment is defined as unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive. And keep those three words in mind. We're going to come back to those in a moment as well. That effectively denies a person equal access to the recipient's educational program. And finally, sexual harassment includes sexual assault, dating violence, domestic violence, or stalking. And those terms are referenced for definition within several federal statutes, including the Clary Act. Quid pro quo may be express or implied. So the DOE, while this is referenced in the preamble, not in the regulations itself, acknowledges that a student may be, or an employee may be a victim of quid pro quo sexual harassment, even though it's implied by comments or behavior rather than expressly stated. Sexual assault, the term itself, one of the four terms in the third definition, is defined as forcible or non-forcible sex offenses under the FBI's Uniform Crime Reporting Program. And the UCR contains several types of forcible and non-forcible sex offenses, including in the forcible category, rape, sodomy, assault with an object, and forcible fondling. And this is where the definition of consent that all of us who are familiar with and have worked with Title IX over the last several years since the Dear Colleague letter in 2011 are probably most familiar with, in the sense that consent has become an obvious topic of concern and definition for our schools, as well as the Department of Education, and both complainants and respondents in determining whether there is an incident of sexual assault. In the definition under the UCR, you might note on page 4, the initial definition of sex offenses forcible provides that it is any sexual act directed against another person without the consent of the victim, including instances where the victim is incapable of giving consent. And you will note that within the definitions under that, each of those provides that it is an offense if the person is raped or suffers sodomy as a result of an action against their will, or even if it's not against their will, if they're incapable of giving consent because of temporary or permanent mental or physical incapacity. So it's the traditional situations that all of us have seen and addressed and discussed for years, and the not untypical situation of a complainant or victim who may have been incapacitated and unable to give consent because of alcohol, drugs, or other situations. So we'll come back to consent in a moment, but keep that in mind. It is most relevant in this definition of sexual assault. Dating violence is defined as violence committed by a person who is or has been in a social or relationship of a romantic or intimate nature with a victim. The statute goes on to note that there are various factors to consider in determining whether there is a dating situation, including the length of the relationship, the type of the relationship, and the frequency of interaction between the parties. Domestic violence is what most of us are familiar with through multiple news stories and other information. This is violence involving either married couples or cohabiting couples or couples who share a child or similarly situated scenario involving two people in a domestic type situation. And finally, stalking is defined as engaging in a course of conduct directed at a specific person that would cause a reasonable person to fear for his or her safety or the safety of others, or suffer substantial emotional distress. And when we started this part of the presentation, I referenced you to keep in mind the conduct on the basis of sex as a pre-qualifier, so that the preamble notes that there may be situations where there is stalking between two people, but it's not on the basis of sex and consequently does not constitute sexual harassment. The regulations themselves do not contain a definition of consent, and each recipient must clearly define within their own policy the definition of consent, and that it will be applied uniformly and consistently between both men and women, and in every incident involving an allegation of sexual harassment. So it is up to each school to define consent. I'm sure many of you are aware and deal with the fact that many states have their own campus sexual misconduct statutes, some of which provide for a definition of consent, some of which provide for criteria as to what any school should include in a definition of consent with broader flexibility. But I note this because it's important that we keep in mind that it's each school's responsibility to define consent under Title IX regulations, and that we need to keep focus on other non-Title IX statutes or regulations that may impact that definition. Turning to the second definition of sexual harassment of severe, pervasive, and objectively offensive behavior. I think this is an area that is going to create tremendous disputes as to interpretation. The criterion is that it is a reasonable person's perception that this conduct is severe, pervasive, and objectively offensive. But it's going to come down to an obvious question as to what constitutes severe, what constitutes pervasive, and what constitutes objectively offensive. And keep in mind that all three of these criteria must be met in order for an incident to qualify as sexual harassment within this definition. So for instance, if it's a single incident between two students, it obviously won't be quid pro quo because it's not an employee, and it may not qualify as sexual assault, dating violence, domestic violence, or stalking. So the question is it unwelcome conduct that is severe, pervasive, and objectively offensive? My thought is that if it's a single incident, it is not going to be, quote, pervasive and won't come within that definition. So even if it's objectively offensive, even if it's severe, it may not rise to the level of being sexual harassment within this definition. And as we move forward through the regulations, I think you'll appreciate how important the definitions are in a school's responsibility to respond to a reported incident, either on a supportive measure approach or through the more formal grievance process. Lastly, in this area, I guess 6 months ago, no one thought this might be relevant, but within the preamble, there's a little discussion on online sexual harassment. It is not addressed in the regulations, but DOE notes that if online communication is part of a recipient's educational program or activity, that it may be subject to the regulation, and that it will be very fact specific. So that's all the guidance they've given us on it at this point, but I know that many institutions, and probably most of you, are still in the process of deliberating what your fall semester is going to look like. And as you're reviewing your sexual misconduct policy to come into compliance with Title IX, I would suggest that you spend a few minutes thinking about that, because there may be certain instances when online harassment may be a real issue. And even if it's not necessarily within the scope of the Title IX regulations, it may be something that you wish to address in your code of conduct. Let's move to the recipient's general response and the threshold criteria on page 7. Section 44 deals with a recipient's response that is not related to a formal complaint. The Section 44 deals more with the supportive measures that a school is obligated to provide to a complainant and a respondent, potentially, in the incident of an alleged act of sexual harassment. So Section 44 begins by stating that a recipient with actual knowledge of sexual harassment in an education program or activity of the recipient against a person in the United States must respond promptly in a manner that is not deliberately indifferent. And again, words are critical throughout this little 3-line provision of the regulations. All 4 of those criteria must be met in order for a school to be obligated to respond under Section 44. The first is sexual harassment. We just discussed the definition of that, and that's why I was suggesting that the definitions are so important, because if you have an incident that doesn't rise to the level of being sexual harassment within those definitions, the school has no obligation to address that particular incident. So these are like thresholds, check the box issues that anyone who has knowledge or obtains knowledge of an alleged incident of sexual harassment needs to consider. The new criterion under 44 that we did not discuss for sexual harassment is actual knowledge. And actual knowledge is defined in the regulations. And this is one of the 2 primary places where there's a differentiation between post-secondary schools and elementary and secondary schools. In a post-secondary school situation, the actual notice only occurs when the recipient's Title IX coordinator or any official of the recipient who has authority to institute corrective measures on behalf of the recipient receives knowledge of an alleged incident. So post-secondary, 2 classes: the Title IX coordinator and a person who has the ability to take corrective measures, which would normally be fairly limited in a school situation and should be probably identified in your policies and code of conduct. In a secondary or elementary school situation, any employee who is informed about an alleged incident is considered to have given the school actual knowledge. Much broader definition. And for those of you who may be involved in elementary or secondary school situations, this means that your employees, all of your employees, need to know and understand Title IX and their obligations to at least report it upstream to somebody who can proactively respond under the Title IX guidelines. I don't think that every employee needs to know the details of the regulations, but they certainly need to know that if they become aware of an incident, it's their responsibility to get the information to the right person. keep in mind too, this is a clarification of what's been floating around for some time, and that is the question of whether resident assistants, faculty members, other employees in a college or university situation are considered to be a representative receiving actual knowledge. Under the regulations. That is not the case. So that's the second criterion. Thirdly, education program or activity is defined as locations, events, or circumstances over which the recipient exercises substantial control over both the respondent and the context in which the sexual harassment occurs. And it also includes any building owned or controlled by a student organization that is officially recognized by a post-secondary institution. In other words, a fraternity house or sorority house. Locations and events are fairly easy to recognize. Circumstances are a little broader, presumably an off-campus field trip or a sports team traveling to another city for a sporting event or competition come within that definition. But again, this is a rather restrictive definition of what constitutes an education program or activity and would not extend by the terms of the regulations to an off-campus house or apartment or two students going away for a weekend, things like that. Finally, the incident must occur within the United States. And the Department of Education in the preamble spends quite a bit of time talking about the language of Title IX and the reason behind DOE's interpretation that the incident must happen in the United States. So one of those criteria is not met. If you go back to page 7, if any of those 4 criteria are not met, if the incident happens overseas, doesn't qualify for a response under Section 44. The incident is never reported to the Title IX coordinator or an individual with authority to address the issue. No actual knowledge at a college or university level. Doesn't happen within an education program or activity, doesn't qualify. Or it doesn't meet the criteria of sexual harassment as in the definitions. It is not an incident that requires response by the institution. On page 9, we just wanted to note that the little language deliberately indifferent. The exposure that a school has to liability to the Department of Education for failure to respond to an incident that meets the 4 criteria is if the school is deliberately indifferent. And as we get to the back of the materials, we're going to talk about record keeping a bit. And one of the requirements under the record keeping provisions is that recipients not only track their response to alleged incidents under Section 44 or the grievance process under Section 45, but that they also note why they were not deliberately indifferent in addressing these type of reports. So this is a real issue. And while DOE has taken out the monetary damages provision, DOE still reserves the right to take remedial actions and or to withhold federal funding, although I've never seen that. I don't know that DOE has ever imposed a termination of federal funding. Somebody may have a different answer on that. But it's a real deal for liability if a school is deliberately indifferent. Turning to Roman numeral 5 and the recipient's response to qualifying incidents of sexual assault, if an incident meets those 4 criteria, then a recipient's response must treat complainants and respondents equitably. We talked about that term equitable. It pops up all over the regulations, and this is one of those places. By offering supportive measures as defined in 106.30, we'll talk about that in a moment, to a complainant. In other words, the complainant must be afforded the opportunity for supportive measures, and by following a grievance process that complies with 45 before the imposition of any disciplinary sanctions or other actions that are not supportive measures against a respondent. So to two things are imposed upon the school in this situation under 44. First, supportive measures for the complainant, and secondly, assurance to the respondent that there will be a complete grievance process and a determination of responsibility before there are any sanctions or other actions imposed. Although supportive measures may be provided for a respondent as well as a complainant under 44 and our requirement of the school. If a formal complaint is filed, the recipient must follow the grievance process and go to 45, as well as providing the supportive measures under 44. So the regulations provide that the Title IX coordinator has certain obligations upon becoming aware of this alleged incident. That includes, and this is on the bottom of page 9, promptly contacting the complainant to discuss the availability of supportive measures. Consider the complainant's wishes with respect to those measures. Inform the complainant of the availability of supportive members with or without filing a complaint. And finally, explain to the complainant the process for filing a formal complaint. The term supportive measures is defined in 106.30 as non-disciplinary, non-punitive, individualized services which are reasonably available without fee or charge to the complainant or the respondent before or after filing a complaint, and even when no complaint is filed, and they must be designed to protect the safety of all the parties or the recipient's educational environment or deter sexual harassment. So in paragraph G on page 10 is an excerpt from the regulation itself, noting that supportive measures may include counseling, extension of deadlines, modification of work schedules, escort services, restrictions on contact, changes in work or housing location, leave of absence, security, and other similar measures. So there's much flexibility afforded to schools in providing for supportive measures. And if you look back at paragraph F, the purpose is to ensure safety of all the parties, to ensure a safe educational environment, and deter sexual harassment. So these supportive measures may be crafted to address different situations. Any participation of a complainant or a respondent in supportive measures is to be confidential, and the Title IX coordinator is responsible for implementing those supportive measures. A couple of exceptions to the supportive measure general guidelines, which are they are not to be sanctions until the grievance process is completed and a respondent is held to be responsible. Emergency removal is recognized under 44C if the school undertakes an individualized safety and risk analysis, determines an immediate threat to the physical health or safety of any student or other individual that relates to the allegations, which would otherwise justify removal, and provides the respondent with notice and an opportunity to challenge that removal. So if a school determines that a respondent is a risk to the complainant or other students, or there's another safety and risk situation that the school believes warrants removal of a student from campus, that student may be suspended at that point in time. Administrative leave is addressed under 44D, and that relates to employees who may be a respondent under a Title IX case, and the school is given the discretion to place an employee on administrative leave pending resolution of the case. I'd like to move to a discussion on formal complaints. A formal complaint is defined in the regulations as a document filed by a complainant, or it may be submitted by the Title IX coordinator alleging sexual harassment. Again, that term is important, against a respondent and requesting an investigation. Importantly, At the time of filing that formal complaint, the complainant must be participating in or attempting to participate in an education program or activity of the recipient with which the formal complaint is filed. In other words, they have to be a student or attempting to be a student, which I guess would be an incoming freshman or someone on campus for the summer. The complaint may be filed with the Title IX coordinator in person or electronically or by mail. And if the Title IX coordinator files the complaint, they obviously are not a party. They are simply making the complaint to initiate the investigation process. Once that formal complaint is filed, the school is obligated to undertake a grievance process under Section 45. However, the complaint may be dismissed on a couple of bases. The first, noted at the bottom of page 11, is that a recipient must dismiss, this is must dismiss a formal complaint if the conduct alleged in that complaint would not constitute sexual harassment, even if it were proven. Again, the sexual harassment, that criteria is a threshold under 44 for a school's obligation to undertake supportive measures under 44. It's also a threshold for a school to address a formal complaint through a grievance process. Again, a mandatory dismissal if the incident did not occur in the recipient's education program or activity. And finally, if it didn't occur in the United States. So once again, as I mentioned a moment ago, if the incident doesn't meet these criteria, the school has no obligation to move forward with the complaint under Title IX. However, the school may, within its code of conduct, have more expansive definitions of sexual misconduct or harassment, which would provide that the school would move forward with the grievance process. Secondly, the recipient may dismiss a formal complaint, so it's non-mandatory, but may, if the complainant notifies the Title IX coordinator that he or she would like to withdraw the complaint or a portion of the complaint, one of the allegations. If the respondent is no longer enrolled or employed by the recipient, the case may be dismissed. And finally, specific circumstances may prevent the recipient from gathering evidence in order to reach a determination. So, for instance, if the Title IX coordinator filed the complaint asking for a formal investigation and the complainant refused to cooperate, if it were a one-on-one situation and the complainant or student who is alleged to have been sexually harassed simply refused to cooperate in the investigation, the school may determine that that particular complaint should be dismissed. If it is dismissed, then written notice must be given to both parties. And under 45B4, the recipient has the option to consolidate complaints into a single matter. If it involves more than one respondent or more than one complainant against one or more respondents, or one party against the other party on multiple claims, or different claims arise out of the same facts and circumstances. So there is the opportunity to consolidate and streamline the investigation and hearing process. The process for formal complaints, the process itself. So we talked a bit about what comprises a formal complaint, some of the criteria. The grievance process, this is called the grievance process under 45. First of all, it must comply with the Title IX regulations, and both parties must be treated equally. The process itself must treat the complainants equitably by providing remedies to the complainant where a determination of responsibility has been made against the respondent. So this is at the conclusion of the hearing and the determination that there are remedies to a complainant which can address his or her situation. The process must follow a grievance process that complies with 45 before the imposition of any disciplinary sanctions, something we talked about again earlier under 44. And the remedies need not be non-disciplinary or non-punitive and need not avoid burdening the respondent. So unlike supportive measures, which are designed to assist a complainant or a respondent essentially upon an allegation of sexual harassment, the remedies that may be imposed upon a respondent may be beyond those of simply being supportive. The grievance process must require an objective evaluation of all relevant evidence, and we're going to hear the term relevant come up repeatedly in the next few minutes. This includes both inculpatory and exculpatory evidence, and it must provide for credibility determinations that cannot be based upon a person's status as a complainant, a respondent, or a witness. In other words, credibility determinations need to be objective throughout the process. The persons involved in the grievance process, the Title IX coordinator, the investigator, and the decision maker cannot have any conflict of interest or bias, either generally against victims or respondents, or against the individual complainant or individual respondent in a particular case. And this criterion comes up several times through the regulations, but it's important both on a global perspective and on an individual case perspective that the recipients, representatives in that process are not biased, have no conflict of interest, and that they can treat respondents and complainants individually and on a general basis fairly throughout that process. A recipient must provide training to Title IX coordinators, investigators, decision makers, and any person who facilitates an informal process. And at the back of the materials, we'll talk for a few minutes about the training criteria. That's also included there. The process must include a presumption that the respondent is not responsible for the alleged conduct until a determination regarding responsibility is made at the conclusion of the grievance process. And obviously, most of us are aware that this issue of presumption of non-responsibility is important and has been since the Dear Colleague letter was issued in 2011. Much discussion about whether the processes proposed by DOE since 2011 were skewed one way or the other toward the complainant or respondent, and consequently, this is a clear directive in the regulations that the presumption of non-responsibility persists through until the conclusion of the process itself. The guidelines for the grievance process must provide for reasonably prompt timeframes. There are only 2 timeframes within the regulations themselves. It also includes a provision for temporary delays, and one of the reasons for that may be a concurrent criminal investigation, which has been a discussion many times since 2011 because of the initial 60-day guidelines for completing a school-based investigation when a criminal investigation was going on simultaneously. The process description must also include a range of possible disciplinary sanctions or a list of those sanctions, and it must state whether the standard of evidence to be used is either a preponderance of evidence or clear and convincing evidence. So 2 different standards, one lower than the other, obviously. But I'd note to you that the school must apply the same standard of evidence for formal complaints involving students as for formal complaints against employees of the institution, including faculty. And if your school has a faculty handbook or a contract with employees or faculty that provides that in a disciplinary proceeding, the burden is one of clear and convincing evidence, and that extends to allegations of sexual harassment, that will be your standard for students as well, because it cannot be a lower standard for students than it is for employees, including faculty. Important point to keep in mind. Many of us will need to check what other either codes of conduct, faculty handbooks, contracts may set as that standard and ensure that we're consistent under the Title IX policies. The process must include procedures and basis for appeals, supportive measures that are available, that the investigation will not require, rely upon any information which is legally privileged, and that this must be incorporated in the entire process. The, the regulations go on to note that a recipient's treatment of a complainant or a respondent's in response to a formal complaint of sexual harassment may in and of itself constitute discrimination on the basis of sex. So if a school treats either the complainant or the respondent inequitably, that may be a basis for complaint by the party who was affected by that treatment. The notice requirements are laid out on page 14, and I'm going to kind of just skip through those, at least some of them, except to note that the initial notice must identify the parties involved, the conduct allegedly constituting sexual harassment, and the date and location of the alleged incident, and give the parties sufficient time to prepare before an initial interview. Many of the other items in here are covered in the grievance process that we just went through and guidelines. But I would note to you that in the notice to the parties, we are obligated to notify each party that they may have an advisor of their choice who may but need not be an attorney. So an advisor is a right that both parties have throughout the entire grievance process. And I know there's some schools out there that will provide an advisor for both a complainant and a respondent from the inception of a grievance process and pay that expense. I'm not sure how many of us may be doing that going forward in light of where the economy and higher education is today. That is not an obligation. When we get to the hearing process, though, that is an obligation, and we'll talk about that in a moment. If the school's code of conduct prohibits knowingly making false statements or submitting false information, that needs to be noted in the notice as well. And if the investigation is expanded, that needs to be a supplemental notice to the parties involved in the case. Let's move to the investigation phase of a formal grievance process. Initially, the recipient is charged with conducting the investigation, and the burden of proof and the gathering of evidence is a responsibility of the school. And DOE in the preamble talks a bit about this, and the rationale for that is that schools are charged with providing a learning environment which is free from sex discrimination. And if there is an allegation of sex discrimination and sexual harassment, that it is a burden on the school to establish whether or not that is the case. A Title IX coordinator may be the Title IX investigator, although as many of us are probably aware, that's a difficult situation for many Title IX coordinators, and particularly under the new regulations where supportive measures are mandated and the Title IX coordinator is charged with the responsibility of managing supportive measures both for the complainant and the respondent. I think it's going to be a very, very, very difficult situation for many Title IX coordinators to serve as the investigator and satisfy that requirement of being unbiased and having no conflict of interest, or at least not exposing themselves to the allegation of being biased or having a conflict because of their multiple hats that they're wearing during these cases. If you turn to the bottom of page 15, both parties are giving an equal opportunity to present fact and expert witnesses. Neither party may be restricted in their ability to discuss the allegations or gather evidence. Both have the right to an advisor throughout the grievance process, although the school may impose limitations on the advisor's participation in proceedings provided those restrictions are equally applied. And my partner in Title IX Solutions, Tom Denton, who is our Director of Investigations, former police chief, has a private investigative agency and is very active in these Title IX investigations. Did a webinar for us a couple of weeks ago talking about virtual investigations and virtual interviews. It's on our website. If you didn't get a chance to see it then, you're welcome to visit. But one of the things that Tom discussed was his approach as an investigator to addressing the attorney at the inception of an investigation interview and discussing the school's policies toward the advisor's participation in that interview, so that there was a clear framework between the attorney, the investigator conducting the interview, and the witness or complainant or respondent before that interview began. Very helpful, very interesting conversation. At the conclusion of the interview or the investigation process, all parties and their advisors must be given access to the complete investigation file as to all information directly related to the allegations. And this is something that's very important that the investigators understand, the Title IX coordinator understands, because this is a requirement under the regulations that the full file be made available to the parties and their advisors, and they have 10 days, a minimum of 10 days, to provide written comments to that material. The investigator then has to take that information into account in writing up his or her investigative report. But I suggest that this is important and that investigators and Title IX coordinators clearly understand the importance of having an organized investigation plan, organized investigation files, that they retain records in an organized fashion, and that they present them to the parties in that fashion. Because as most of us know, the litigation that surrounds much of the complaints that are brought to court by complainants or respondents against schools focus on a violation of their rights of due process. And the fact that this is required under the Title IX regulations and consequently will be required in the school's grievance processes means that it needs to be done correctly and comprehensively. The investigator does not need to include all of that material in his or her report. The report is supposed to reflect relevant information as it moves to the hearing process, but that entire file goes to the hearing for the parties to have available to use in the course of the hearing process. So it's important that this information is captured and preserved, and that includes paper information, interview notes, audio-visual recordings, Zoom meetings, whatever it might be. So the investigator completes his or her report and then moves the file forward by issuing the report at least 10 days prior to any scheduled hearing. It has to be provided to the parties and their advisors. So when that report is done, it's relating the relevant information and then moving to the hearing process. Again, I think it's important for investigators to understand the process as well as each school's education and program activities, their consent standards, the standards of proof, and really a total familiarity with the process before they begin an investigation. Following the completion of the investigation, a case moves to the hearing stage. A decision maker manages the hearing, generally with the assistance of the Title IX coordinator in orchestrating things, but the decision maker cannot be the investigator, cannot be the Title IX investigator. The decision maker, and that's singular or plural, so some schools may have a multi-individual panel, others have a single decision maker, but that individual cannot be, or individuals cannot be the investigator nor the Title IX coordinator. A post-secondary school must have a live hearing, and a live hearing is optional for elementary and secondary schools. Although if an elementary or secondary school is not going to have a live hearing when the investigative report is completed, and that's still a process that's done under the prior conversation here. That has to be provided to any of the parties involved, and they have a chance to submit written responses and written questions to parties or witnesses. So there's an alternative process, but secondary and elementary schools are not required to have live hearings. Those live hearings may be physically live with everyone in the same place, or they may be virtual at the discretion of the school. If it's going to be live with everyone in the same place, these parties each have the opportunity to request that the parties be in separate rooms, so, and then connected so that they can hear each other throughout the entire process, but they don't have to be face to face in the same room. They can each have their own location. If they are, one of the things that the decision maker is charged with is being able to manage the technology to make that happen. If a party does not have an advisor at the hearing, and this is, I'm coming back to the advisor we talked about a bit earlier, at a hearing, the advisor is a right of each party. And if a party does not have an advisor, the school is obligated to engage an advisor without charge to the party to represent that party during the course of the hearing. And the advisor, which may or may not be an attorney, is charged with asking questions of witnesses and conducting cross-examination. And the regulations are very explicit that never will one party be allowed to cross-examine the other party. Kind of interesting that the Department of Education estimates that attorneys involved in the grievance process and through this hearing process may spend an average of 60 hours of preparation and participation in this entire process. Even at a rate of $200 an hour, that's $12,000 that a school would be required to pay, and perhaps for both parties, as well as for the school itself. So we just had a conversation the other day with an institution that was particularly focused on the cost of addressing one of these Title IX hearings, even just the hearing process itself. I would note that when the questions are submitted on cross-examination, that the decision maker is required to make a determination before the question is answered as to whether it's relevant. Only relevant matters may be brought to the hearing. So it's going to put a burden on the decision maker to be experienced with the concept of relevance and how it applies in a particular case. And I think there will be certain situations where an outside decision maker, an experienced attorney or mediator or someone will be important to control a hearing process, particularly if the advisors are relatively experienced and aggressive trial attorneys. Questions about a complainant's sexual predisposition or prior sexual behavior are not relevant unless they are brought to disprove that the respondent committed the conduct alleged or to prove consent. And I would note that if a party or witness does not submit to cross-examination, in other words, a party doesn't show up for a hearing, that the decision maker must not rely on any statement of that party or witness in reaching a determination of responsibility. But the decision maker cannot draw an inference that the party's lack of showing up means that what they said was not true, but they cannot take their statements to the investigator into account. And I know this seems kind of alien, and part of the conversation that's gone on since the regulations were proposed in 2018 is that the grievance process that DOE has set out in these final regulations will be a disincentive to victims coming forward, because a victim complainant, in going through the hearing process, and keep in mind there has to be a hearing process and a final determination in order to impose a sanction against a respondent, that a complainant will be dissuaded from pursuing the formal complaint because of the anxiety of going through the cross-examination process. And I think that's just a conversation that is ongoing between victims' rights advocates and respondents' advocates. And whether you believe there's legitimacy to that or not, that is certainly an ongoing dialogue. But the reason that that's there is that there is a basic precept in, at least in American criminal law, that every defendant has the right to face their accuser, and that in this case, a respondent is somewhat akin to a criminal defendant, not exactly, but the concept is that you can't be the subject of disciplinary action without the opportunity to address through your attorney on cross-examination a complaint. Now that may be resulting in a complaint being dismissed. On the other hand, if it's an incident where there's one complainant but 12 witnesses, it may not be relevant. So we're going to wrap up here in about 3 or 4 minutes. For those of you who are keeping track of your time, we wanted to give everybody a little time to get started in the beginning and take a few minutes here at the end. So on determinations, the decision maker writes up the determination and has to lay out a description of the allegations themselves, the process that the school went through in investigating the case and reaching the determination, which is again why it's important for the Title IX coordinator and the investigator to have a detailed file. The procedural steps that were taken all the way through, findings of fact, conclusions regarding the application of the recipient's code of conduct to the facts, because the Title IX policies will be incorporated into there, and a statement and rationale for the result of each allegation, and then a determination of remedies that will impact the respondent, as well as any remedial measures or supportive measures that are recommended for the complainant. And finally, the determination needs to note the procedures and permissible bases for appeal. Title IX coordinator is responsible for implementing that determination. There's a little discussion on standard of evidence. We've covered that already, but I wanted to include it here because I think it's relevant, particularly for a decision maker to note those guidelines on standards of evidence. Both parties have the right to seek an appeal by a written application for appeal. The decision maker on the appeal cannot be the Title IX coordinator, cannot be the investigator, and cannot be the initial decision maker. So I think the schools are now wrestling with the fact that they have to provide at least 3 individuals in this process, and probably a minimum of 4 if they're just going with a single decision maker model. And they have to provide training for all of these people and perhaps pay for the advisors to assist the parties in the hearing process. So it is a bit of a challenge, I think, for some schools to find volunteers, if that's the right term. The appeal decision maker reviews the information. The parties can submit written arguments and ultimately either affirms or may refine or reject the determination. So I'd like to just point out one other thing here on informal resolutions, which is on page 20. This is something that is probably relatively unused in Title IX cases to this point, but the new regulations suggest that this is an alternative method for schools and parties to resolve Title IX matters. Informal resolutions can only be applied once a formal complaint is filed, but they can be initiated at any point after that complaint is filed through the investigation and hearing process stages. The mediation, and I'm going to call it mediation, there are other forms out there, needs to be voluntary. The parties need to be informed of the process. They need to know that it's an option, and they need to consent in writing to mediation or arbitration. For those of you who are not familiar with mediation or arbitration, arbitration is essentially like a trial. The parties select an arbitrator, and the arbitrator hears evidence from the parties or from their attorneys and maybe or maybe not witnesses, and then makes a determination which is binding on the parties, just like a court decision. Mediation is a process where the mediator, and mediators have to go through training in Title IX under the regulations, just like Title IX coordinators and decision makers and investigators. But mediation is a process for an individual who has training not only in Title IX, but also in mediation and tries to facilitate a settlement or resolution between the parties. And in this case, keep in mind that mediation is going to involve normally a complainant, at least one complainant, a respondent, at least one respondent, and presumably the school itself, because any type of a sanction that involves a disciplinary measure would incorporate the school into the process. So it will be an interesting process, but I think it will be very, very helpful in many cases. Mediation is now part of the legal system in many, if not all states. In some states, it is an option in the course of civil litigation. In some jurisdictions, it's mandatory before a case goes to trial. And I think that people have learned much about mediation over the past several years and find it very helpful. It's also helpful in the context of avoiding some of the stress of these investigations and the cost, fees and expenses and legal fees that would go into a full-blown grievance process. So I think that this will develop over time as an alternative for many schools and parties to utilize as a method of resolving Title IX and sexual misconduct issues. As an aside, we are working with a mediation group now that we have some experience with to put together a panel of mediators, 6 or 8 attorneys, some of whom are former judges, some of whom are former counsel for a university or college, who will have a background in Title IX as well as mediation. These are all experienced mediators, and we anticipate offering this as a service to colleges and universities throughout the United States shortly, and we'll post that information on our website and send out an email as that becomes available. But I think it will be very helpful for schools. I'd like to wrap up by just noting the training requirements are noted on page 21. I'm not going to spend time on that except to reference you to it. It's an obligation of schools to ensure that their people involved in Title IX are trained and the materials are kept available. Record keeping is noted on page 22. Again, schools are obligated to keep track of records as to actions under Section 44, as well as grievance processes under Section 45, and information as to why they were not deliberately indifferent in a matter. Remedial actions by DOE are noted on page 22. The dissemination requirements are noted on page 23. Page 24, retaliation is prohibited by any individual in connection with any type of Title IX investigation. And if there's a complaint alleging retaliation, that may be filed and go through the grievance process under sex discrimination that we previously discussed. All information related to Title IX investigations is confidential. And finally, educational institutions that are affiliated with a religious organization may apply for exemption from part or all of the Title IX regulations based upon religious tenets. Thank you for your time and your patience today. We appreciate it. I hope it was helpful. If you have any questions, as Adrian suggested, feel free to address them to myself or Adrian at any time. Thank you.
Great, thank you, everyone. I'm sorry that I couldn't look at your questions and tell Pat at the same time. So I'm thinking what I'll do in the follow-up email tomorrow is put your questions in the email and we'll address them so that you all will see the response. So don't worry, I haven't forgotten about you over there. I'm so sorry. It's just I only have one screen. So I I will be in touch. Please be on the lookout for the responses to the questions in the chat box. I'll take note of them now. For the link to the recording of the webinar itself, which please feel free to share with your colleagues. And also, a certification of completion. So this will be it's an hour and 15-minute course. So I will be in touch, and we hope to see you next time. Thank you so much.
Thank you.